Tom Abbate, and today we're going to start the first of a two-part series regarding state and federal drug crimes. Today we're going to focus on the state, and just so that you're aware, search and seizure is often one of the biggest issues in any drug case. However, that's covered in a separate video, and so today with regard to the state drug crimes, I'm going to be focusing on just the punishment ranges and the natures of the offense. So, to begin with, all drug crimes are based on the possession of some kind of substance, chemical, herbal, or medicinal, that the government has marked as a dangerous drug or narcotic. This can range from marijuana all the way up to cocaine, and also covers things like Xanax, Oxycontin, things that are available by prescription. Now, with regard to the prescription drugs, it is only illegal to possess those drugs if you do not have a valid prescription. For instance, Oxycontin is an opiate derivative, so it's kind of in a similar vein to say something like heroin, but where heroin is always illegal to possess, Oxycontin is legal to possess in certain instances with a valid prescription from a doctor. If you are caught with narcotics that you cannot produce a prescription for, then you are looking at having committed a crime and being punished accordingly. Now, the thing to keep in mind with all state drug crimes is that there are a lot of factors that go into what the specific punishment range you are facing is. For instance, marijuana starts off at a Class B misdemeanor, which, other than like a speeding ticket or maybe a public intoxication ticket, you really can't get any lower in the state system. That punishment range for a Class B misdemeanor is up to 6 months in the county jail and a fine not to exceed $2,000. Okay, now from there, depending on the amount you have, you can go up. So, for instance, simple possession of marijuana that would get you to a Class B misdemeanor is any amount less than 2 ounces. Once you cross the 2 ounce mark, then you're looking at a Class A misdemeanor, and the punishment effectively doubles. That amount goes from about 2 ounces up to 5 pounds. Okay, once you have 5 pounds of marijuana, you're now in the state jail felony range. That's at least in Texas. It may vary depending on what state you are in. With these crimes, though, you can go all the way up to a first-degree felony with a higher minimum sentence. For instance, if you have over 400 grams of cocaine, you are looking at a minimum sentence of 15 years. And that can go all the way up to life because it's a first-degree felony. Okay? So where exactly you fit on that punishment scale is going to depend on what drug you have and how much of it you have. Okay? Now, the thing to keep in mind in the Texas system is that none of these drug crimes are 3G offenses, which is important because, under the old 3G system, it's now Section 42A of the Texas Code of Criminal Procedure, but we always just refer to it as 3G because that's what it used to be. Under that section, you are ineligible for parole until you've served half your time in actual calendar days. These are high-level offenses, usually something violent. We don't really need to go into it here because none of the drug crimes fall under that, at least in terms of simple possession. Now, what that means is that if you are convicted of one of these offenses, you are eligible for parole once you've served a quarter of your time, and that is counting both the actual calendar time plus any good conduct time. and it includes any time that you spent in jail prior to being sentenced. And so, even if you get a really high sentence, you got to keep in mind that you're not necessarily going to do all of that. You will be on parole that whole time, which is effectively like probation without the hearing to throw you back in jail. At least not in front of a court. You get an administrative hearing. But, if you get a 25-year sentence, you're not necessarily looking at doing the full 25 years in prison, absent, other criminal history and your behavior while you're in prison. But you do have to face the fact that you're going to be on parole for that full term, even if you're out of prison much earlier. So it's very important that you hire good counsel to help you with these things because, especially here in Texas and some of these smaller counties, they really don't like drugs. And, they will go out of their way, the state, to try and get the highest sentence they possibly can in an effort to try and close down the drug market in their area and to make an example out of someone. So you've got to be very careful because you can end up essentially on the worst form of probation that you could possibly be on for a very long time. Now, there has been a lot of movement in recent years. It hasn't quite made it all the way to Texas, but it seems like it's kind of coming here. To be a little bit more lenient when it comes to drug crimes. Recently, within the last year or so, Texas, to some extent, decriminalized marijuana possession. Not entirely. It's still a crime if you're caught with it, and don't take this as I'm saying go out and smoke all the marijuana you want. But before, you couldn't have anything that was even made out of hemp. Now they've changed it to where these products like CBD can be sold, even though they come from the same plant that the marijuana also comes from, typically. So there's been some movement to try and ease this back because what was learned from the drug war is that it doesn't appear that anything you can do will ever actually stop someone from doing drugs if they are addicted to them. And so there's been more of an emphasis on providing treatment. What this typically, or at least means, and how it's typically handled in Texas, is that you're looking at a deferred adjudication probation. That is also covered in another video, which I would direct you to look at if you're interested in what deferred looks like. But just understand that you're basically on probation with a gun to your head. In that if you don't complete that probation, you are looking at being sentenced to incarceration. But there may be treatment programs, different things that you have to take as part of that. And that's all been towards this emphasis of treating these more as a disease as opposed to a crime. Oregon, within the last year, just basically made everything legal, and that shows you kind of how this is going, at least in some locations. But it's very important that any attorney that you hire on a drug case delves into the facts about you. You may have past trauma. Maybe you had a bad childhood. Maybe you lost someone close to you, and you turned to these chemicals as a way of coping with whatever that trauma was. That is information that could be very valuable in terms of working out a plea bargain or getting a lower sentence from a jury if you are found if you are found to be guilty of this crime. And so it's very important that whoever you hire not only knows the law, but is willing to take a look at you and really delve into who you are as a person to show that to the court. Because if your attorney doesn't do that, you're just a name on a piece of paper with a criminal charge attached to it. You need someone that's going to humanize you so that even if you can't beat the case ultimately, at least you're not looking at 25 years on the worst form of probation you could ever be on.